You just can't seem to follow the rules.
She kept chasing me. That's it. And then she went to talking about calling the police and all that. She control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
You just need to just stop blaming them.
All right, everyone. Today we're looking at an extremely intense court hearing involving Judge Simpson and a defendant who just can't seem to stay on the right side of the law. He's back in court because he tampered with his tether device and even met up with the same woman he was previously charged with domestic violence against, and Judge Simpson completely tears into him for ignoring clear court orders, because if you're out on bond or probation, messing with your tether is practically asking to be sent straight back to jail. Yet this guy is loaded with excuses, so this should be an interesting one to watch. Let me know what you think about this court hearing in the comments as we go through it. And now let's jump in and see Judge Simpson bring the hammer down on him.
Mal Carter. Thank you. Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. We're going to stand in for the purpose of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony. And then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's on tether. What's that? He's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
I understand that the attorney is doing everything possible to help, but if we're being honest, this guy completely dug himself into this situation. He didn't just disregard the judge's warning, he essentially walked out of the courtroom, looked at the law, and decided it didn't apply to him, openly committing violations despite being clearly told to stay in line. That's like talking back to your mom and then immediately breaking something right in front of her. You're practically inviting disaster, and now he's standing there acting confused as if he didn't see this outcome coming. But just wait, because Judge Simpson is about to deliver the wake-up call of his life, and it's likely going to be harsh. If he thought he could stroll back in and talk his way out of it, he's about to learn the hard way that judges don't forget, and he might as well get comfortable because there's a strong chance he won't be walking out of that courtroom a free man.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they had contact with the police officer and admitted to having contact with the victim. denied the assaultive behavior, but did admit
As it
to
relates
having
to her
contact
phone, right?
with her. Now, because the
The return
defendant,
phone, right?
because the police officer wasn't speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back, represented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the score for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation, revoke the probation, and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand they're only allegations, but try to give you the darn benefit of the doubt regarding everything, because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, can I say something?
You can say whatever you want.
Oh, this is about to get interesting. So let me make sure I understand this correctly. This guy has a restraining order against this woman, and the last time he was in court he was clearly told to stay away from her, far away, not even to be anywhere near her, and now he's been caught meeting up with her and somehow thinks he can talk his way out of it. This is about to become very compelling because I already know whatever excuse he's about to give is going to sound completely unbelievable. There's just no realistic way he can spin this to make it seem like it wasn't his responsibility, but I'm honestly curious to hear him attempt it, and at this point he might as well claim he was kidnapped and forced to be there because I have a feeling Judge Simpson is going to come down hard on him for this. Let me know what you think he's about to say here, because brace yourselves, it's likely going to be outrageous.
She put up on me. I was in the room playing my game, and she came in the room. And
then you get up and leave.
Tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety on his other matter. Anything you want to say before I post sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm gonna be by myself. I just know
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program. Is what I meant to say. Thank you. Defendant's remanded.
And that, ladies and gentlemen, is exactly why you should always follow the law. Look, I completely understand making a mistake or a bad decision and later realizing it was foolish, but it's an entirely different situation when you go right back out and repeat the exact same behavior after already being warned. That's not a simple error, that starts to reflect who you are. And this guy made it pretty clear he doesn't care about the law at all, so at this point jail might be the only thing preventing him from walking straight back into another courtroom. I also have to mention Judge Simpson because he truly does not tolerate this kind of behavior, and it's honestly refreshing to see. Though I understand his frustration, you can see on his face that he's exhausted by repeat offenders wasting his time. And I don't blame him one bit since judges hear excuses constantly and can probably tell within seconds when someone isn't being truthful. In most states, violating a restraining order is a criminal offense that can lead to serious jail time depending on the circumstances, so when someone stands there pretending it was accidental, the judge is likely thinking they can explain that to a cellmate, and it was obvious Judge Simpson didn't believe a single word of that weak explanation, which I genuinely respect. Anyway, I'll wrap it up here. Let me know what you thought about this court hearing because it was definitely intense, and if you enjoyed it, don't forget to like and subscribe for more content like this since I post daily. I truly appreciate you all for watching. Thank you so much, and take care.